I must say the only reason I am here is because of the Free Market Foundation in more than one respect. One, because she invited me to do the talk, and secondly, the subject matter of what I'm looking is really been introduced to me by the Free Market Foundation several years ago, and so I've had to worry about these things for several years because of you. We're going to look at the Magna Carta and the return of the sheriffs of Nottingham. Sheriffs because there's more than one, as you will see. I'm glad everybody's come because the Magna Carta is celebrating its anniversary this year. They didn't sign them those days, they sealed them, the sealing of. Now just to make sure nobody's sleeping, how many years ago was the Magna Carta sealed? 800 exactly. This is its 800th year. Now it is one of the most important and the most historical documents in the world. Everybody knows that except the British. I don't know why. Now, has anybody got any idea where was it signed? Runningmead. Okay, that's a good answer. Secondly, any idea what the word Magna Carta means? The big charter. Okay, I'm glad you could answer that because the Prime Minister of England went over a couple of months ago to America, and they thought they'd invite him onto the Leatherman show. And as you will see, the one country that reveres the Magna Carta is the Americans. So one would think at least somebody would tell him, be careful, I'm going to ask you about the Magna Carta. So when they said to him, what does the word Magna Carta mean? He said, I got no idea. Which means not only is he bad at history, he's bad at Latin. I mean, Magna, big, Carta, charter. I mean, you don't have to be a genius to work that out. And they said to him, where was it signed? He said, I think on an island somewhere. There is a little island at off Runningmead, but it wasn't signed there. It was sealed at the field of Runningmead. So it is extraordinary that the British themselves, and we will have a look at that, do not hold the document in as great a regard as the Americans do. But because it's the 800th anniversary this year, a lot of attention has been paid to it. And if you've been watching Sky, you'll see they brought the 4 copies that they have available in the world, and they put them in the London University. They invited people to make an application. 50,000 people applied to go and see it. They only allowed 1,200 people to go and actually see the 4 copies together. And then the Sky thought that what they will do is they will give you a little bit of background. So they went to Runningmead, and there's a memorial that's been erected there by the Americans, and they showed you the memorial. But they forgot to tell you there's actually 2 memorials. So how can a TV station actually go to Runningmead and go miss half the story? So it goes to show you the English don't really appreciate the Magna Carta. But not a problem. As you'll see, that was probably good news for that. So this is not a story about the Magna Carta, but about the protection which the Magna Carta has given society, the freedoms which we've had for 800 years. And now since 2008, those freedoms have been eroded, which has resulted in the return of the sheriffs of Nottingham. Everybody thinks of the Magna Carta. The king at the time was King John, and everybody thinks about the Magna Carta was only about King John. But actually it was about King John and his sheriffs. And so the king isn't the problem, the sheriffs are the problem. So we want to have a look how the sheriffs have returned. First time in 800 years. So shows you how effective that Magna Carta was. It could keep them at bay for 800 years. But you'll understand that in better detail as we go through it. Okay. It's always easier, I think, to follow a lecture, which is always boring and difficult to follow, if you concentrate on the problem. So it's easier if you say, okay, I understand now what the problem is. So I thought instead of me trying to explain in a laborious academic way what's the problem, let me try and illustrate the problem. Then you can see the problem, and you can see it. The problem is what I call the rise of the unitary states within the state. Now, see, I put my name there because I invented the phrase, so you won't find it anywhere else, so just to make sure it's under there. And secondly, for reasons I won't really go into, the best and only way to really discover the truth is to start off with an observation. So you've got to start off and say, yeah, I can see that. And then say, what I now have to do is to try and understand it. So If you simply say, I have an idea, then it's very philosophical and metaphysical and doesn't really help us. It's a real problem. So you have to get to understand the problem. And I'll illustrate the problem. Now, the problem of the states, within the states, I actually discussed it at a previous meeting, so I thought I'm not going to spend half the night trying to go back over that particular ground. I'll just give you an illustration. So here's a recent illustration, comes from the 27th of January 2005, and this is an announcement which was made by the Financial Services Board, which is our regulator. So this is an announcement really set out as a warning to the insurance community to see what's happening if you don't toe the line, you see. That's the registrar, that's the Financial Services Board. The respondent, that's the guilty party. They agreed to pay a penalty of 250,000 rand. Now think for a minute, when you read all the newspapers, when you think of a court of law imposing a fine of 250,000 rand. Think, when last did you see a fine of 250,000 rand? That's like somebody going to jail for 50 years, you see. 50 years or 250,000 rand. It's an enormous fine which courts would seldom impose. So it's a large fine over here. Now, in reaching the agreed penalty, the Financial Service Board took several mitigating circumstances into account, including the fact that the guilty party has never appeared before the Financial Services Law Enforcement Committee before, and the guilty party accepted responsibilities for its actions and cooperated with the Registrar's Office. And then if you want to read the details in more detail, it's available at the Financial Services Board. And then it carries on to tell you who is the Financial Services Board's Enforcement Committee. So that's part of the quotation. I just emphasized what that the last part showed. The Enforcement Committee is an administrative body that has the authority to impose administrative penalties and cost orders on offenders of the Financial Services Board's legislation. So think about it for a minute. We have a body that's imposed a fine of 250,000 rand. It's not a court of law. So somebody other than a court of law thinks they're a court of law which can impose a fine. And why? Because they broke the law. But which law? The Financial Services Board's law. So we have an institution which can make its own laws, impose its own penalties, and has its own judges to do that. So it's a state within a state. So that's the point, if you can see the problem. Not a court of law, and not violating the laws of the land, but laws which the regulator himself has made. So that's the problem we want to do. And that's simply an observation. That's something which we can see. Oops, wrong way around. Constitutionally speaking, but within the institutional economics framework. Institutional economics is really from the work of Douglas North. And Douglas North, who got a Nobel Prize, very simple statement: institutions are important. What are institutions? Institutions are those things which impose constraints, like a constitution or the law of the land. So a state is an institution which has three powers. One, it has an executive power. That is, it can use state resources to achieve certain objectives, not necessarily good ones. It has legislative power. It can make laws. And it has an adjudicative power, and that is the courts of the law. And historically, liberty and prosperity have flourished where these three are separated. So, and I don't have to labor that point. Leon has got thousands of pieces of statistics to demonstrate the countries in the world which have always done better is where those three are separated. In South Africa, we are a state that works within the separation of powers. We have a government, we have a parliament, and we have a judiciary. So that's the state which we work. But what we just saw was something different. We have seen that some person has been found guilty and been penalized for 250,000 rand because he broke a law which the state didn't pass by a body which is not the courts of the land. So there are other institutions which have evolved, which have managed to acquire all three of those powers which are in one. So what we have is officially a state which is a state which acts within the separation of powers, but within that state there are other institutions which have taken all those three powers for themselves. So those are the states which I'm talking about, the states which exist within the state. The separation of powers is embodied in the idea of the rule of law, and the doctrine of separation of powers is attributed to the French writer Baron de Montesquieu, who wrote the book The Spirits of Law in 1748. Of course, the separation of powers didn't come with Montesquieu, but he managed to articulate it in such a way that we could say, okay, that makes sense that we should feel. But the separation of powers goes back much earlier than that. Now, the rise of the unitary state within the state, the rise of these institutions which have now acquired all three of the powers for themselves. And the one which I've given the illustration, the example which we looked, we have the Financial Services Board. Now that's clearly part of the executive. It's got to be one of those three. So each job would have been to operate in terms of the law of the land. But it is also a legislator. As you've seen in that particular statement by its own words, we've imposed a fine of 250,000 rand because the guilty party violated our laws. So it passes its own laws. Something which has become far more explicit and has become explicit in terms of the recently passed General Law Amendments Act, which is a 280-page bill amending more than 10 acts of Parliament. Now, what happened is when that 280 pages came out, and now if you want to really try and stay awake, try and read 280 pages of legislation. So when I was given a copy of that, I said, that is very good, but I think that will stay on my desk forever. I'm never going to work my way through it. But eventually, my eye caught onto a proposed change of Section 55 of the Act, was 53. If you read that very carefully, and you then separate all the irrelevant words and just take the relevant words, what that simply says is the registrar makes his own laws. And so we said, well, that's unconstitutional. The registrar has no power to make his own law at all. So we went to the standing committee to go and say this should not be allowed. And it was quite interesting because at this point in time, if you see the problem, you would say, but look, the industry itself should be very concerned. So when we went and made representations to the standing committee, the National Treasury was also there. So I don't really understand what these people are talking about because the industry is quite happy with the legislation. So fighting a war for I don't know who, because the industry says we are really quite happy about it. And then, was it true? Was it that the FSB will be able to make its own law? After the General Law Amendments Act, which is 280 pages, another act went to Parliament, and that act could not get through Parliament before the general election. Now, when you have a general election, you have a new Parliament. So the old Parliament cannot continue with the legislation of the previous Parliament. Quite logical. You can imagine in England, if you have the Conservative Party that's in power, they lose the election, and then you say to the Labour Party, you have to carry on with our legislation. So no, it doesn't work that way. So whatever doesn't get through, it has to start all over again. But the FSB wanted to get on with the program. And so it said, well, you know, we have a problem because Parliament didn't agree to it. They said, oh, don't worry about it. In terms of the legislative powers we now have got, we don't need Parliament. We'll continue in terms of Board Notice 158. So they simply said, forget about Parliament. We carry on. Yeah, it is. And in the meanwhile, we'll do what we want to do, and then we'll see if we can get something through Parliament to make another law in any event. So in a sense, Parliament has now become fairly irrelevant. And so that other statement where the FSB says we make our own laws and we punish people for violating our own laws is perfectly correct. FSB has its own committee. It has an adjudicator. It doesn't have to go to the enforcement committee. It can simply say, we found you guilty for 250,000 rand. If you'd like to plead guilty, just give us the check and carry on. If you want to argue with us, then we put it in the enforcement committee and they will impose it. But either we do it or they do it, but you're going to pay us the 250,000 in any event. So it does that. It then ends up with all three of the powers within the state which we live, which has the finest constitution in the world. Okay, now with that background, let's just now turn to the Magna Carta. Why it's 802 years. Now, why do we want to look at the Magna Carta? Because that's where constitutional democracy started. So it's a good place to go back and to see it. It is a document which King John was forced to sign or to seal in 1215. And one would argue, and certainly King John understood that England was on the brink of a civil war. The answer was, or the options given to him was really quite simple. Either you sign it, or our armies will decide who signs it or not. And he decided, okay, he would rather sign it than go to war under that. So King John and his army versus the barons and their armies. Now what the king wanted, King John's wanted, was arbitrary powers, especially the power to tax, that is to take private property. And what the Magna Carta famously, and this then goes down now in history as the cause of several civil wars to enforce that particular. No taxation without consent. So the idea that in the Western society there can be no tax unless Parliament agrees to it comes from the Magna Carta. The King John was forced at Runningmead to sign the Magna Carta, the great charter. Incidentally, one of the nicest judgments I've ever read is the recent judgment with Mark Shuttleworth. Because you remember what happened? Is Mark Shuttleworth decided he wanted to leave the country. So he then went to the Reserve Bank and he said to the Reserve Bank, I want to leave the country, I want to take my money. They said, okay, we have a 10% withholding fee, so give us 250 million rand and you can leave. So that's what he would have liked him to say. Went to the Reserve Bank and the Reserve Bank said to him, we actually don't talk to you. We don't talk to anybody. You must go to one of the banks which we've appointed out as our agent. And he says, look, for 250,000 rand, I think I'd rather talk to you. He said, no, we don't talk to you. So they sent him to the Standard Bank. So Standard Bank, he said, look, this is the problem, I want to leave. He said, no, that's what the law says. He said, okay, but I want to talk to the Reserve Bank. No, you can't talk to the Reserve Bank, but you fill in a form. So he said, okay, I'll fill in a form. Now, will you take my objection to the Reserve Bank so that they know that I'm unhappy with this? Yeah, no problem at all. We will do that. Comes back, I say, okay, pay us the 250. He said, what did the Reserve Bank say? No, they're not going to debate this. Turns out they never took anything to the Reserve Bank. They said, no, we don't talk to the Reserve Bank about what you want. All you have to do is pay the 250 million rand, which he then paid. But he paid it under protest, and eventually it went to court, went to the Supreme Court. Now, one of the easiest and most beautiful judgments I've ever read. Only thing that's missing, they didn't quote the Magna Carta. Should have quoted the Magna Carta, because since 1215 in the Western world it's accepted that there is no tax without Parliament. So the simple question which the SCA had to ask is, did Parliament impose the 250 million rand tax? And the SCA says this was imposed simply by the Reserve Bank. There's no authority in law. Parliament never agreed to it. The Reserve Bank's lawyer said, yeah, but the Minister of Finance mentioned it in his budget speech. So, well, they didn't vote on it, didn't get signed by the President. That doesn't make it law. So will you please give him his 250,000 rand? So the principle of no taxation without consent, no taxation without a law from Parliament was upheld by the Supreme Court. So the only great regret I have, they didn't refer to the Magna Carta, because that's where it all started. Now, what we have seen is the rise of the states within a state, the rise where bureaucrats can impose multi-billion rand fines. They've done it in a competition tribunal, and I think it's about 3 billion or 4 billion rands. Overseas, with the banks, must be going on to something like 100 billion rand at this point of time, which will be imposed without a court of law, without any legislation, without ever having to plead to a charge, without even having a charge formulated. The question is, why did that happen? Answer really given by one of the world's greatest historians. Now, the only thing that surprises me about this particular quotation is why I'm the only one that seems to know about it. It is such a brilliant quotation explaining what happens in the world that I would have thought that in every essay on history or economics, this would be the opening paragraph. This is very simple. What Lord Acton was trying to explain is, what is it that drives history? And in a lecture which he then delivered, he said, the law of the model world, that power tends to expand indefinitely and will transcend all barriers abroad and at home until met by superior forces, and that produces the rhythmic movement of history. So what he was saying is, the world consists of people who want to get power, and they will do anything and everything in their power to get that power until they are stopped by another power. So if you have a system which allows a bureaucrat to pass the laws to get money for himself, what will he do? That's what he will do. He will simply pass a law to make the money for himself. Let me illustrate. In the 1840s, England for the first time decided to have a police force. And so what they decided when they had a police force is they will have an incentive scheme. if somebody is convicted, then the policeman will get a bonus. And so that was the great incentive scheme. Anybody got an idea what happened? They got lots of convictions. Anybody got an idea? It's known as the Blood Money Acts because of what happened. The police began to frame people and began to lie simply to get the bonus. They began to train criminals and breed them until eventually they committed the great crime. And then they would be found guilty, just so the policeman would get the bonus. Why did that stop? Stop because people realized what was happening? No. It's because the juries, 12 men true, good and true, would no longer convict on the evidence of the policeman. So whether a person was guilty or innocent, the English population, from where the jury was selected, would not trust the evidence of a policeman. So it became apparent that the legal system could not function, and those acts were then sort of repealed. So if you have a system which allows people to be able to enrich themselves through state power, then that's exactly what they do. And that's not surprising. That's human nature. If you can do that, you can do it. For example, the Financial Services Board, how is it funded? Any idea how the Financial Services Board is funded? No, it's imposed fines of 47 million rand so far. What happened to the 47 million rand? No, FSB keeps it. But that's not the point. How do they fund themselves? Yeah, it's a levy. So you pass a law which says a bureaucrat can work out what salary he wants and then pass it on to the industry and they just have to pay it. Any idea how the FSB has expanded since 1994? From how many people to how many people? And how many rands to how many rands? It's gone from about 10 people to 500 people, from 1 million rand to 500 million rand. We're about to get what's known as the Twin Towers, so they're going to replicate themselves. They're going to make another one of those and send it to the National Treasury. And when the National Treasury was explaining it, there's a little footnote there. Oh, by the way, this will be funded by a levy on the industry. So we're about to see another 500 million rand imposed. Why does it happen? Lord Acton. Power tends to expand until it's stopped by a more superior power. If you give somebody the power to decide what salary he wants and somebody else is forced to pay it, what salary is he going to get? I mean, it's so simple. I mean, how can anybody make a mistake like this? Okay, the truth of the matter is that individuals will take unto themselves whatever powers they can for their own personal benefit until stopped by a more superior power. 800 years ago, that superior power was the Magna Carta. So that's what stood in the way of this for 800 years. People do what they do because they can do what they do. No other reason. I mean, it's so logical. If I can say somebody must pay me, the chief executive of the FSB gets 5 million rand a year. If I can say somebody must pay me 5 million rand and I write out and say, okay, the levy is paying me 500 million rand. That's what I'm going to do. I'm going to get 5 million rand. Not a problem. Institutional economics says that institutions matter. So it says that what Lord Acton says will happen, will happen. Superior power must be put in place to stop that. So we must have institutions which prevent it. The separation of powers is one of those institutions. The country has the separation of powers, but it's been subverted by institutions which have all those powers with himself. If the power is or has expanded, it's because institutions have failed. So if what is said has happened, it's because the institution we put in place 800 years ago in the Magna Carta has ceased to work. We have to simply put it back. Okay. Okay, the Magna Carta 1215, it stopped not only the king, but also the sheriff of Nottingham. Now, the Magna Carta, as I've already indicated, is revered by the Americans, but not so much by the British. There was the Magna Carta is in display in America at the Smithsonian, right next to the Declaration of Independence and the original American Constitution. And there was a little boy there with his mother, and he said, pointed to the Magna Carta, he said, well, what is that? And the mother had great difficulties trying to explain to the boy what is the Magna Carta. So the American soldier went over and said, that is what we fight and die for. So it is the document which embodies the safeguards, the constitutional safeguards, which give us the liberty which we've enjoyed for 800 years. So it's a fantastic principle and document. In America, the British, we've now had the four brought together for the first time. One of the British copies were taken to New York in 1932, and 14 million Americans in New York queued to see the UK copy. When America entered World War II, the American copy was the first document to be moved to Fort Knox. So the Americans held it in very high regard. And in the 1970s, the memorial, which I've already spoken about, was erected at Runningmead by the American Bar Association with the motto, freedom under law. When John F. Kennedy was assassinated, the Queen of England and her government then donated an acre of land to the American people, on which the very plain Kennedy Memorial stands today. That's the one I was quite surprised that when Sky News went there, they didn't actually look at the second memorial, only one. And on the memorial is the words from John F. Kennedy's inaugural address, let every nation know, whether it wishes us well or ill, that we will pay any price, we will bear any burden, meet any hardship, support any friend, oppose any friend, to assure the survival and success of liberty. So Americans hold it in that sort of regard. The English are a little bit more enigmatic, but I will argue that the English actually have got it right for a different reason. But it's when my English colleagues kept telling me they don't really regard the Magna Carta as a particularly important document, that I had to spend a lot of time trying to understand why. And in the end, of course, you could work it out. It's not that they do not regard it important. King George V, just after the troops landed back at France to liberate Europe, as he was going back from London to Windsor, as you go past there, you then pass Runningmead, and he then pointed out when you pass Runningmead, that's where it all started. That's where constitutional democracy started. Lord Denning, regarded probably as the greatest 20th century judge, said the Magna Carta is the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. The English simply have no faith in written documents. So it's not the principles behind which they have no regard for, or less regard for. It's the fact that you need to have a written document. You know, there's a concern about reducing these things in writing, and it's a concern which, if you read any of our Constitutional Court judgments, you will then begin to understand, is if you reduce the document to writing, then the belief is that the rights are embodied in that document. The rights are outside of the document. They are reside in the freedom of a nation rather than the document itself. The document is simply an expression of that, and the danger of reducing them to writing is that you tend to believe eventually that the rights are in that particular document. So the English have more faith in English common law, and a barrister once said to the judge, well, where exactly is this English common law? And the judge then, the barrister had the misfortune of saying, when he asked that, and the judge replied to him, it is stored safely in the breast of His Majesty's judge. So the barrister then had a bit more wisdom and said, yes, my lord, and safely stored there, I might say. So the English rather have faith in the ancient liberties of the Englishman, which is embodied in the common law rather than in a single document by itself. A.V. Dicey, England's most famous constitutional scholar, pointed out that you can have all the rights you like, but unless the society uphold those rights in a document do not help you. So in the end, Dicey argued that freedom is from society itself. The document itself does not have. And to this day, England still does not have a written constitution. They still do not believe in embodying these ancient rights of the Englishman into a document. As I've pointed out, Prime Minister David Cameron embarrassingly was ignorant on TV concerning virtually everything about the Magna Carta. The single most important principle which people think of the Magna Carta is no taxation without consent. Now, all of that is very interesting, but what has it got to do What's the Magna Carta have to do with the regulator? Now that's really interesting because virtually everybody I've seen who ever talks and speaks about the Magna Carta have never read the Magna Carta. And they all say everything in the Magna Carta is now absolutely obsolete. There's no point in reading it. There's no point. If you do take the time to read it, and we will look at some of the clauses, then you will see that actually those principles are still there today. And why? For 800 years we have not seen the Sheriff of Nottingham. Okay, why have a look at the Magna Carta and the modern regulation? Because we have seen the return of the Sheriffs of Nottingham, which you all know, of the notorious Robin Hood fame, and the actions of the sheriff, as we will see when we look at the specific provisions, were outlawed by the Magna Carta. And why have we forgotten that? Oliver Wendell Holmes, a great American jurist, told us why we'd forget it. The necessity of law becomes forgotten, and the ingenious minds set themselves to account for it. So if you ask, where did all these liberties come from? Instead of saying, well, let's go and read the Magna Carta and see some of them, people begin to work out their own ideas as to where they came from. So go back and read the provisions of the Magna Carta, which we have a look. Okay. There's only 68 clauses in the Magna Carta, and let's just look at some of them. Clause number 29. The pleas of the Crown shall not be held by our sheriffs, constable, coroners, or any other bailiffs. What's the pleas of our Crown? Bear in mind it's written 800 years away. The English language is not that easy to follow. The pleas of the Crown is a court of law. That's where you deliver the pleas to the court of law, the Crown. So what that says is that the government shall not have any court. Our sheriffs shall not be judges. Our sheriffs and constables and other bailiffs will have no role in the judicial process. We cannot have a regulator being the judiciary. That's what we have today. It was outlawed 800 years ago. Government courts were abolished. Indeed, they were outlawed. The judicial function, that's where we get the separation of powers, was separated from the government and vested exclusively in the judiciary. So-called regulators can have no judicial powers. So we cannot have a financial services board acting in its own enforcement committee. We cannot even have a retired judge, which is the latest thing, acting on the judiciary. It has to be a judge who is appointed as a judge, sitting as an ordinary judge in an ordinary court of law. So Section 29 outlawed the idea that we can have a government court. Section 38, in future no official shall place a man on trial upon his own unsupported statement without producing credible evidence to the truth of it. The judiciary in the Western model is an impartial adjudicator of the disputes placed before it. The judiciary itself cannot investigate the crime, it cannot prosecute the crime, it cannot go and institute the crime. It has to be done by the state, and the judiciary is totally impartial. Again, the characteristic of the modern judiciary which we've come down through the 800 years. So what was outlawed in the Magna Carta then developed through constitutional law to give us the separation of powers as we know. The government cannot institute any proceedings on its own initiative or secure a conviction from its own evidence. The judicial process is exclusively complaints driven. When the UK established its own first police force by Sir Robert Peel, the judiciary was not part of the executive, the police force was not part of the executive, it was part of the judiciary. So the function of the police was to do the investigation, place it before the prosecutor, but the judiciary itself cannot institute the claim. What we have with the Financial Services Board, it's its job to go and carry out inspections and then come back and say, we found all of these kind of things we violated, now these are the fines which we're going to impose. That was outlawed by Section 38 of the law. Section 39 is an interesting one because in the years which would come, some of the world's greatest jurists would look at like Lord Coke, and the interesting thing is the laws of the land. No freeman shall be punished or fined except by the lawful judgment of his peers or by the laws of the land. Now, the phrase the law of the land, of course, is part of the English vernacular today. You know, what is it? It's a sacred, it's the law of the land. Now, bear in mind, in 1250 when they wrote, there was no parliament to make laws. So the only law was the common law of the day. So no sheriff shall make up his own laws. The only laws which can be applied and to get a conviction is the laws of the land. Those are the existing laws. So the idea now, as we have seen where the FSB says, oh, I make up my own laws and I prosecute you and I fine you for violating, that was outlawed by Section 39 of the Magna Carta. In 1215, and in law known to the land was the law of the land, which would become known as the English common law. No punishment could be imposed except for a violation of the common law. The sheriff could no longer make up his own laws. All the evil customs connected, so Section 48, all the evil customs connected to the sheriffs and their officials shall be utterly abolished. So in 800 years ago, what we now have, a state within a state, was utterly and totally abolished. An interesting thing about the Magna Carta, these 68 phrases, clauses have been there for 800 years. And to this day, there has been no comprehensive analysis of those 68 clauses. So I would have loved to have been able to pick up a commentary and say, well, that's my interpretation. It's taking plain English. What is the view in the life? No commentary. We would think in 800 years somebody would have written the commentary on it. Okay, so the sheriff no longer had the power to make his own laws. Violations of the laws of the land had to be determined by a court of law, determined by the jury of the peers. The sheriff could not impose any fines. Fine imposed by the jury of peers had to be proportionate to the offence. So where does the 250,000 rand come from? Is it proportionate to anything? No. That's simply because the FSB keeps the money. So that figure will keep going up until, in Lord Acton's sense, somebody stops it over there. So all of those principles today, which were outlawed in the Magna Carta, those are the principles which have come back. So you can see why I say the Magna Carta and the return of the Sheriff of Nottingham. Once you forget the institutions, then that's what happens. Okay, the modern system is not an obsolete, forgotten relic of history, which even the most favored people who read, who think about the Magna Carta think it is. It has morphed into modern constitutional system. Separation of powers, executive, parliament and judiciary laws. Nowadays missing from the rule of law. They should comply with the principle of legality. Only the common law. You couldn't make up your own laws to get the conviction. No penal laws, no retrospective laws. Violations. This is to show you how utterly and totally the sheriff was outlawed. Look what happened after 1800. Violations are now investigated by the police. The police cannot prosecute, they can only investigate. In England, historically, the police were part of the judiciary, not the executive, and the police owed their fidelity only to the law, not to a politician, not to an executive, but only to the law. The case file is handed over to the public prosecutor. The sheriff cannot prosecute a case. The prosecutor is also an officer of the court, as are all attorneys and advocates. They too are part of the judiciary and not the executive and owe fidelity only to the law. Tried therefore before an independent and impartial judge and jury functioning in terms of the due process of law. So the system evolved because of the restrictions in 800 years to our modern system, which has been violated. And so the Magna Carta did indeed utterly abolish the evil customs of the sheriff. That is, until 2008. After 2008, we have seen the return of the sheriffs of Nottingham. Enormous fines, not only in South Africa, multi-billion rand, pound, dollars, doesn't matter which currency you want to, billions of them, imposed worldwide by regulators without any clear laws, no trials, no due process of law, no judiciary, no principle of legality, and no principle of proportionality. So everything which the Magna Carta outlawed has now come back. The power left unchecked and has indeed expanded, as Lord Acton noted would happen. If you lift the restrictions, then the power expands until it is stopped. So what did the Magna Carta achieve? Most would say the rule of law, separation of powers. Those consenting were affected by the laws. Now I have a slightly different view, and that is that the safeguards at the time of the Magna Carta were real safeguards. Today we've replaced these with Chinese walls, and I'm not so sure that Chinese walls are working as effective as it was originally. In the modern elective system, these safeguards are merely Chinese walls. The elected party becomes the government, as is often said in South Africa, the ruling party. The elected party can deploy its friends to the judiciary. The elected party can deploy its friends to the National Assembly, where the laws are made. The bureaucrats know that Parliament will simply rubber stamp any legislation sent to it, no longer laws by the consent of those affected by the laws. I told you when we were involved with the debate on the 280-page legislation, which amended 10 legislations, took it to the Parliamentary Select Committee, and Leon was more involved in what I was. And then eventually the committee made it clear they were just going to rubber stamp it. And so the idea was, no, you won't. It will be opposed in Parliament. And then the decision was Parliament will not debate this act. Parliament will just vote on it. So the legislative body designed to approve legislation does not discuss the legislation it's approving. So whatever the bureaucrat sends, the legislation will pass. So that was not what happened in the Magna Carta. So it seems to me that the walls which existed in 1215 were real walls. These are Chinese walls, which are not working very well. Okay, so that's my story. So as Leon has said, most people disagree with what I'm going to say. One of my colleagues wrote an article which appeared in a publication. So Professor Vivian is sort of isosymmetric. He doesn't like follow the normal sort of lines. But I have got good news for you. Worldwide now the truth begins to dawn. So what I'm saying is now beginning to be understood. Not because what I've said simply, because it's the truth. In other words, it's something you can observe. Other people are observing. So if you take last year alone, Professor Phillips Hamburger wrote a very interesting multi-hundred-page book. The lawyers would say the FSB is acting in terms of administrative law. So what I've pointed out, other people have also begun to realize. So Professor Berger, Chicago University Press, then questioned whether administrative law is unlawful in South Africa, would be unconstitutional. And he came to the conclusion it is manifestly unconstitutional. Well, all you have to do is read the Magna Carta and you would have known that. So there's an entire book which is arguing the same point, much more complicated than the point which I've made. Professor Michael Gleason, what I've spoken about, state within the state, he is saying governments within the government. He has looked at Oxford University Press. He's really asked a question: why is it that the United States presidents never seem to achieve or uphold the promises they make on security matters when it comes to election? Think of, for example, Obama said he's going to close Guantanamo Bay. It's still not closed. Why is it not closed? I mean, he went on the election saying that's what he was going to do. Obama, this is quite amusing because there's a YouTube going around. Obama said that he would pull the troops out of Iraq. Now he's pulled the troops out of Iraq. And there's like 50 video clips of him saying, I pulled the troops out of Iraq. And then the last clip is the statement he recently made. They said to him, but why did you pull the troops out? And I said, but I didn't make that decision. Professor Michael Gleason would point out that where I've said there are states within the state, there are governments within the government. And what he argued is the framework which we understand, executive, separation of powers, he calls them Madisonian institutions. So those Madisonian institutions are not actually controlling the executive. The executive is controlling itself. And the Madisonian institutions simply give you an air of respectability. But in fact, they're not really with the control. Or in my framework, that we have bureaucrats which are operating. Except I think in South Africa we've gone further because our bureaucrats have patently come out and said we want to make our own laws. The Americans haven't done that yet. President Obama is under a lot of pressure because he is acting outside of the law. But we have in South Africa the bureaucrats who are saying we are the law. And the bureaucrats say we have our own courts. We don't need anything beyond that. Okay, conclusion. The modern regulator factually violates the constitutional principle of separation of powers. They take all three of those powers, and that you can observe for yourself. So I don't think that's really a matter of great debate. Increasingly, regulators are simply placing themselves onto the private sector payroll. So the legislation is drafted in such a way is we will impose a levy to cover our costs. So effectively, they simply put themselves onto the payroll to do what they like, and there's no way. Now, all of this is inevitable without the institutional constraints, as Lord Acton pointed out well over 100 years ago. If there are no constitutional constraints, then people will do what they can do to get where they want. Thanks a lot.